Ladies and gentlemen, thank you for joining us today. I have Steven Gurian. Steven is an attorney that specializes in trusts, probates, and everything in between. So, Steven, it's so good to have you here today. I really wanted to have this conversation with you because, doing real estate for as long as I've done, I've run into so many different circumstances where people make the biggest and worst mistakes when it comes to estate planning, inheritance, wills, title, and they end up actually inadvertently taxing their inheritors with extra cost and fees associated with cleaning up that title so that they have full use of the property. So I wanted to clear the air, set the facts straight, and have you bring your professional knowledge to everybody that is watching today so that we can really give them the right way to do trusts, estates, planning, probates, etc. So thank you so much for coming today.
Of course, Milton, thank you for having me.
So in the state of Florida, when is probate necessary?
So short answer is this: probate is always necessary if you passed away and you own something in your name. Essentially, if there's a piece of paper that says you own either a car, a bank account, a house, and you're the only owner of that piece of property, and you pass away, got to go through probate.
Now, I've had a lot of clients who said to me, well, no, it's okay, I'm in the will. Does that make a difference?
Not at all. And that's one of the biggest misconceptions I ever come across in my practice. In 12 years of doing this, I always get that call, hey, Steven, I had a will. Why do I have to go through probate? So a will doesn't really do much for you. All it does is instruct the judge or, basically puts everybody on notice as to who's getting what. I like to think of a will as like a cookbook and the judge is the cook. And basically, you're just telling the judge how to make, whatever meal is in the cookbook. But you still got to go to the judge. You still got to go in front of the court.
Yeah.
It doesn't avoid probate for you.
I had a situation once where a client said to me, but I have a will. And the will, I guess, wasn't done properly so that it wasn't then enforceable. And then she was actually kicked out of the estate. So if you are going to do a will, how can you avoid doing it wrong, right? Like, what's the proper way to do a will where it actually would be enforceable?
Honestly, go to a lawyer. That's probably the best thing to do. I mean, I know, we get a bad rap. Lawyers are expensive. It's time consuming, all that. But honestly, if you want to get something done right, go to an estate planning attorney.
Well, Office Depot says that they can do it.
Yeah, I know. I'm sure. And yeah, I've come across that many times. The do-it-yourself kits.
Yeah.
Yeah. And I fix a lot of problems when it comes to those, do-it-yourselfers.
And so if I were to put something in a trust, do I also need a will?
It depends. I hate to give you the lawyer answer, right? But honestly, if you put everything in a trust, you don't necessarily need a will. I mean, the trust is gonna basically think of a will on steroids. That's a trust. Whenever you put property in a trust, you avoid probate. You get some tax benefits out of it as well. Honestly, if you own real estate or really any kind of property, I think every person should have a trust if you're in that situation.
And how would one go about forming a trust? Like, what is a trust? Is it like a shell company of sorts? Like, how does a trust get formed, and what does it actually do?
Sure. So again, see a lawyer. But yeah, you can think of a trust as a company, right? So you set up a company, and whatever you put inside of the trust, that trust is going to own. And then you obviously have your trust agreement, your trust documents. And that document is going to tell you and tell the successor trustees and the beneficiaries, basically everyone that is a party to the trust, how the property inside of the trust is supposed to be distributed, when, and to whom.
And you can avoid taxation.
There's certain taxes that you could avoid.
Avoid, not evade.
Yeah, avoid that. Very big distinction, yeah, for sure.
So I had a friend of mine, a past client, and she was she became the trustee once her mother passed away. Her mother was a beneficiary. Her father was the original beneficiary of the trust. But his father, I guess her grandfather, made it so that his son, who I guess was a child of good times,
sure,
not have control of that trust because he figured that it would be dissolved once he passed away. And so can you set rules in play where, like if I were to die, I would want my immediate family to be beneficiaries of the trust, but not be able to liquidate the trust. So I have a say passed from the grave. But if I wanted the funds, the properties, if I wanted the chain of title to last 3 generations, I would make it so that their children would then be the trustees in charge of it. And so that's one way I think to make money last 3 generations. That's what they did in this case, and I thought it was ingenious.
Yeah, it's pretty common. So they call them dynasty trusts. So yeah, you could have, real estate, for instance, stay in the trust, not necessarily, in perpetuity, but you could have it last so that, your grandkids, could benefit from it. Maybe your kids get an income interest in the property.
Yeah.
And then once the grandkids hit a certain age, you could give them, title to the property. I mean, the good thing about these trusts is, the world is your oyster. You could do anything you want with these trusts.
Oh, okay. That's actually pretty good to know. And so, difference between revocable, irrevocable trust?
So your revocable trust, you can change it at any time you want. The only requirement is you have to be alive, and obviously the trust has to say that it's revocable. And then irrevocable, once you set it up, you can't change anything that you put in that trust. I mean, there's certain situations where you could appoint somebody called a trust protector, and they could have the ability to either revoke or change the trust, but typically the person that sets it up won't have the power to revoke or amend the trust in an irrevocable trust situation.
So once it's one and done.
One and done. So whatever you put in there, you got to be happy with it, and that's it. You're basically stuck with it.
Wow. So I imagine that's not as popular.
Not for real estate. I mean, typically you'll use it for like life insurance. That's the most common. Yeah, that's probably the most common reason I would see, making an irrevocable trust.
Okay. Now, and when it comes to how long this would take, let's talk about probates. How long does that usually take, and what's the cost associated with probate?
So, if you have me as your attorney, I typically get through them relatively quickly, but I would say in a vacuum, anywhere from 9 months to a year is your typical, what's called a formal administration probate. I mean, there's some probates that could be, a couple of weeks, maybe a couple of months. It really depends. Depends on how responsive your client is in getting you those documents. Depends on the judge that you have. Depends on the attorney. There's a lot of factors that you know change whether or not it's going to be a quick probate or a
Right.
long probate.
Like if you have family members that are showing up out of the woodwork,
Yeah.
that may be part of that estate, that's going to slow things down. I've had some probates where they took 90 days. I really don't think I've ever had a probate in less than 90 days, but I've had some that took 2 years. And I thought that, in my experience, was definitely the client's fault because of quarrels and bickering amongst the family of who gets what, who is due for what.
Yeah.
And, that's why I always say plan ahead, right? And so that either you can avoid the probate or the probate is much smoother. Now, what is the cost typically of what a probate could cost? Like what is that? What should a client have in mind if they inherited a house and has to go through probate? What's that going to cost?
Sure. So probate's one of the few areas of the law where attorney's fees are guaranteed by statute. So typically, the client is going to pay 3% of the value of whatever's in the estate over to the attorney that's handling the administration. So, you got a house that's worth $500K, let's say, $15,000 right off the bat is going to the attorney handling the administration. And that's just for administration. If, like you said, people come out of the woodwork and contest a will, or you have a creditor in the estate and they're trying to collect, an attorney could actually charge what's called extraordinary fees on top of the administration. So on top of that 15K, the attorney's charging hourly for all that, extra service that they're providing for the benefit of the estate.
And so, what if the profit in that $500,000 is the $500,000 the profit or this price of the asset, that the value of the asset that they have to probate?
Yeah, it's the value of the asset. So it's the fair market value of whatever's inside of the probate. Doesn't matter if there's a mortgage on it. Doesn't matter if there's any sort of lien. That doesn't count towards any sort of reduction of the fair market value of the property in terms of calculating fees.
Got it. Okay, so definitely something to keep in mind that when you're leaving a property to an inheritor, that you should have a little money left over to pay for this probate process. Or,
Sure.
I found a lot of times people who are inheriting the property don't have the money to do the probate. What would they do in that case?
So it depends on your attorney. I mean, some attorneys will get paid at the end. So if you're selling real estate, Once the sale closes, they could get paid at closing, or they could wait until the very, very end of the probate. Once the estate is funded with either the net proceeds of the sale of a house, or liquidating a bank account, or whatever cash there is in the estate, then the attorney could get paid at that point as well.
And and so if somebody is inheriting a property, but the will wasn't done properly, or maybe there's somebody that they haven't heard from in a while, how does the probate process take place then? Like, there's a son that just disappeared. Nobody knows whether they're alive or not, but they're part of the will, and you need them in order to get that probate done. Is there a time frame where you can push that forward regardless?
Not really. I mean, if somebody's a beneficiary of a will, you got to give them, their due process. They're entitled to whatever, the will says. So you got to include them, even if, they may slow things down. You got to make sure that they're given notice of what's going on and that they get their due.
And is there any way to sell the property and just guarantee that that percentage is going to go to this person, or do we need them to sign on the dotted line?
In some situations, it could be both. So um, if that person is a personal representative, then they're the ones that are kind of controlling everything that's going on in the estate. But if they're just a beneficiary and somebody else is a personal rep, then yeah, they have to agree to, sell the house, for instance. They have to sign a consent saying, yeah, this is a fair price, I'm agreeing to. Or if they don't, then they have to have their day in court, and then either they or their attorney is going to have to explain to the judge why the price isn't a good price, or why they should hold out for more money, or whatever the case may be.
Can somebody really just protest and say, hey, I want to make sure that my family gets nothing because I have a bone to pick with all of them, and then just contest it every single time and stand in the way of the sale?
They can. Now, whether or not they're going to be successful, that's a different story. But yeah, I've had some pain cases where
Yeah.
yeah, there's roadblock after roadblock after roadblock, which is why, like you alluded to earlier, get that trust done, avoid this.
Yeah, 100%. So I have a crazy situation one time where a girl came to me and said, I'm looking to sell my property. She was actually for sale by owner. So I went and I said, hey, listen, I'd love to help you sell the property. And I got the listing because she said, well, no, it was my grandmother's house and she passed away and she left it to me in the will. And I said to her, I said, okay, it's great if you have the will, but did you know that you're going to have to go through probate? Because she was already accepting offers and signing offers. She didn't know that she had to go through this whole process. And so we determined that, no, it needed to go through probate. She sent me the will. She sent me everything. I didn't know you at that time. So I sent this to another attorney, and he said to me, well, the will isn't done properly. It's not like witnessed, or, it's not recorded in some way. It was almost like just written on a napkin. And then, because the will wasn't written properly, we had to go through probate. And in doing the probate, we found out that when the grandmother bought that property, she used her sister as a co-signer. And so even though her sister had never lived in the property and they had just used her as a co-signer for the mortgage, the sister, who had passed away 10 years earlier, also had a claim. And then her descendants had a claim, which included her aunt, who they hadn't spoken to in 30 years. And moral of the story, she ended up not getting anything because we had to do a probate for the grandmother, and she's not a direct descendant of the grandmother. Her mother and her uncle were. And then we had to do a probate for the great-grandmother, and the only living person then was the aunt, who they hadn't spoken to in 30 years. And so it just became a nightmare. It took about a year and a half, and at the end of the day, the granddaughter, who was on the will written by the grandmother, improperly or not, got nothing.
Wow.
Yeah. And so I always say, it's like I really want people to understand how this works, so that they can avoid the pitfalls and stop making the mistakes, which will then end up as a tax on your descendants, which could also exclude the person that you wanted to have the proceeds of the sale. Now, I had another situation recently where the mother and father that owned this condo, they added their children, I think, to the life estate as remainders on the title through a quitclaim deed. Do you understand? Like, how does a parent do that so that upon their death they're able to transfer the property immediately and avoid probate altogether.
Yeah, so I see that quite often is people will use a quick claim deed as an estate planning tool. I don't recommend it.
Okay.
Honestly, I'd rather put the property in trust. And the reason is this: yes, you may avoid probate if you quick claim the property to whoever you want to leave it to, but you're going to transfer your tax basis in that property to the recipient of the property.
Wow.
So, let's say, we got a house in Kendall that somebody bought, in 1980s for like 100K, probably worth five or $600,000 now,
At
right?
least.
So, yeah, especially now in this market, right? So you're going to transfer your tax basis, so that $100,000 basis to the recipient. So if they turn around and sell it, they're going to be paying, $120,000 in capital gains taxes to Uncle Sam. But if you inherit the property, whether you do estate planning or not, so whether you set up your trust, you avoid probate, or you die intestate and go through the probate process, you get what's called a step up in basis. So the person that's receiving the property, their basis now becomes whatever the property was worth at the time that their mother and father passed away. So that property is now worth 500-600K. If they sell it for 500-600K now, they pay $0 to Uncle Sam. So that right there saved them 120K in taxes potential.
Yeah, wow. I think that's definitely something that people don't really understand. And they're thinking that, well, we'll avoid probate, so we'll avoid that 3% fee, but potentially you're going to be hit with $30,000 or more in taxes for capital gains by trying to save that little bit of money. So I think it goes back to your point. Use an attorney.
Yeah, definitely use an attorney.
Use an attorney. Well, what advice do you have for property owners that would make this easier? I know some people do wills or they even do trusts, but maybe they hadn't updated it in 20 years. How can they establish a relationship with an attorney that is going to make sure that this is done properly and that it's updated and it's current? Like, how often do you need to do that?
Sure. So good rule of thumb is anytime you have a life-changing circumstance, go see your attorney and update your will. So whether, you get married, get a divorce, have a kid, have grandkids, set up a new business, maybe you buy a new property. I mean, something like that, merits, at least taking a look at your documents.
What if your kids just annoyed you at Thanksgiving and you want to cut them out?
You could do that too.
You can do that. All right.
That's the beauty of estate planning.
Be nice to your parents.
You could do anything you want with this. So yeah.
Wow. Well, do you have any disaster stories of like something that just went absolutely wrong and they came to you and they said, hey, help me fix this?
I would be here all day. I'll give you a quick one. So a couple of years ago, I had somebody, come to me with the Office Depot will, and they try to fill it out themselves. And a funny thing is he lived in Florida, but like at the bottom it said, oh, this is a Louisiana form. So that in and of itself, I don't know how that got to a Home Depot. I mean, an Office Depot in Florida, but somehow it did. And he's filling it out, and he just put his nephew's name where it said, I nominate, nephew to be the personal rep. And then he put a big X in the paragraph where it actually talked about, transferring the property that he wanted to put in there. So he just didn't know what he was doing. And it turned out, this guy didn't have any kids of his own, was never married. And then he had about a dozen or so brothers and sisters, some of which predeceased him. And they had kids. So long story short, this one person was supposed to get the property. We wound up splitting that property 36 ways.
Wow.
So yeah.
So everybody got a Whopper Jr. at the end of the day.
Yeah, basically. Basically.
That's amazing. Well, how could one avoid fraud and manipulation? Because, there's often times where the parents are alive, but maybe they're not all there yet. And somebody goes in, swoops in, has them sign a form, and all of a sudden the family is cut out. Does that happen very often? And how can somebody avoid that?
It does. So unfortunately, what winds up happening is people put off estate planning, to almost the very, very end. Like nobody wants to face the mortality. Nobody really wants to spend money on something that isn't necessarily going to benefit them, but somebody else. So what I recommend doing is get the estate planning done early. Because once you hit a certain age, people could say, oh, there were, that will was obtained by undue influence, or somebody coerced them into splitting up their estate this way. So get it done early. Yes, you're gonna spend money. I mean, there's no denying it.
Yeah.
But that honestly is the key. Just get it done now. Don't wait.
Spend the money in advance. Now, I had a situation where a client of mine had power of attorney for their mother. and I listed the property with that power of attorney while the mother was alive, but she had just had a stroke and she was recovering and she was in a convalescent center. We listed the property, power of attorney, son put the property for sale, and then the mother actually passed away unexpectedly about a week later. And so the listing agreement was still enforceable, but at that point, the son couldn't sign on behalf of the mother because the power of attorney was null and void, right? We had to go through probate. How could somebody avoid that? Having the power of attorney, but if something were to happen to the parent in the middle of a transaction, how do we avoid a delay?
So honestly, what I would do in that situation is definitely set up a trust because, presumably the person that, the mom in that situation would have been the initial trustee of the trust and she could have done whatever she wanted with the property. But if she passed away, there would be a successor trustee in her place that could continue with the sale of the property and then distribute the net proceeds to whoever the beneficiaries are.
Well, yeah, so it sounds like trust is really the way to go. In order to avoid all these common pitfalls and mistakes, put it in a trust.
Yeah, put it in a trust and then definitely tell your family, hey, I did estate planning. Another mistake people do is they try to hide their estate planning. They don't want everybody to know, hey, I did this. It's okay to be open about it. That way everybody's on the same page, everybody knows who's getting what, and it avoids fighting in the future.
Yeah, yeah. Well, I don't know if too many people want to tell their kids that they may be worth more dead than alive, but that can happen. We covered tax liabilities, but are there any scenarios where the deceased, I guess, was attempting to enrich their descendants with this inheritance, but ended up causing them a huge tax liability and did them damage instead? Like how that I've heard of this. What circumstances? How could that happen, and how does somebody avoid that?
Honestly, the quick claim deed, that's probably the number one culprit, like we had talked about earlier. Like it's okay that you want to avoid probate, but plan the right way. And the quick claim deed is not the way to do it. Because like I said, you transfer your basis, you're going to wind up paying the IRS more than you probably would the probate attorney to handle the probate. So in that situation, definitely set up even if it's a revocable trust, just to make sure that the right people are getting the property,
Right.
that you're paying as little taxes as humanly possible, and that everything is done without having to go to the court system.
I think back to your main point, get an attorney.
Get an attorney, 100%.
Pay for the professional. Just like a buyer may pay a buyer broker, a seller may pay a listing agent, you need a professional that is going to be working on your behalf. And if you're dealing with trusts, estates, planning, get an attorney.
Yeah, I mean, that's why we're here, right? I mean, professionals are on this earth for a reason, and it's okay to pay them. It's okay to use them. That's why we're here, to make, the consumer's life easier.
Get what you pay for.
Exactly. Definitely get what you pay for.
Let's see. What about I'm in a probate process, and then I'm halfway through the transaction and I realize, oh, mom, dad had a whole bunch of like stock certificates that we found inside their credenza we didn't even know about. Does that stop the probate process?
No, not at all. So the personal rep just has to, I guess, go to the bank or, the brokerage and say, hey, look, mom passed away. Here's the death certificate. Here are the court orders. I need to transfer these assets over to the estate. So it shouldn't slow anything down.
You can still sell the house.
You could still sell the house.
Go back and do the rest later.
Correct. You could go back and do the rest later.
Do you have to pay twice?
You don't have to pay twice, but your fee is going to go up if you find that.
You find more assets, right?
Yeah, you find more assets, yeah.
Okay. Yeah, I actually had a friend whose grandfather passed away, and there was a warehouse, a strip mall, a lake house, another property, and then when they were emptying the house, they found stock certificates and a whole bunch of other stuff that nobody even knew about. And I was always wondering, I'm like, well, then how did they unwind that trust? It must have taken a while. So I guess it goes back to your earlier point. When you're doing your estate planning, let everybody know, or at least let one trusted person know, right?
Yeah, I mean, the more people that you let in on it, the better, because you're going to avoid the infighting. And you said it. You've told everybody that's in the trust or who isn't in the trust, look, you're getting this or you're not getting that, and you're going to avoid the court battles in the future. So be open and honest about it. That's probably.
Now, let's say my last point here. I want to get my estate done, but I want to have a third party that is unaffiliated to the family so that I can avoid infighting. And who's in charge of the trust or who's the executor of the estate, how would I go about finding somebody that's impartial, that I can trust, and would it be the attorney?
The attorney can do it. I don't know if a lot of attorneys would do it because it's a lot of responsibility. There are independent trust companies that can be the trustee. They are expensive. Certain banks offer trustee services, but there is definitely people that are out there, companies that are out there that can serve as an impartial, third-party trustee to your trust.
Wow, fantastic. Well, listen, I appreciate you answering all my questions today. I hope I didn't grill you too hard, but really what I wanted to do is provide answers for everybody so that they could go back to this video, see what they need, clarify some of their questions, and then contact you for extra help. So we'll have all his contact information below. So if you have any questions, reach out to Steven directly. Steven, what's the name of your law firm?
So if you want to do a 1031 exchange, it's affiliated 1031. If you want to do probate or estate planning, Easy Estate Probate.
Fantastic. And you'll definitely find them online. So we'll have all the information here below. Thanks so much, everybody, for joining us today. And I hope we brought some clarity to the situation.